Kelly, is there an inch? Please feel free to interrupt me, stop me, flag me down, ask any questions. I will say this is not sort of the official DCYF training document. This is not the official rollout. This is my perspective sort of as the consultant, but it's also a lot of the information that was provided during the roundtables and the consultation. So it's consistent in that way. So to the extent that you missed those or you were out of office during those, this is the perfect time to sort of catch up on what the big conversations around the policies and procedure revision process was. So, obvious background. As you all know, even better than I do, because I'm located in your sister state to the south, Oregon, but Washington has sort of always really led the way when it comes to issues related to Indian child welfare. In fact, a lot of the cases that predate the Indian Child Welfare Act and talk about tribal jurisdiction and the role and parents' patriae position of tribes to their families are from Washington state. Obviously, ICWA was passed in 2011. I'm sure a lot of you have been following in the last 3 years. We've seen a lot of states pass their first ever state Indian Child Welfare Acts. Washington was way ahead of the game. You guys beat all the rest of us by a long shot. And there's been this long-standing, very rich government-to-government partnership between the tribes in Washington and the state agency, which I had the pleasure of learning has had a variety of names over the course of the last 40 years, but is now currently identified as DCYF. The last time the policies and procedures were updated was in 2016. And that was because that was the year that the big federal regulations came out, which made a lot of sense. In the last 3 years, your Supreme Court has been very keen on taking a look at how ICWA is applied in Washington and has provided a great deal of guidance, sometimes guidance that is crystal clear, sometimes guidance that one might say is clear as mud in terms of how ICWA and WICWA should be applied. And so it seemed like a really good time to take a minute to revisit the policies and procedures, make some updates related to those cases, but then also, as we were really bringing together a group of tribal and state partners, take a look at how to provide the best possible guidance to caseworkers and other employees as possible. So there were some really clear sort of guiding lights for the policy and revision process. It may surprise you. I'm kidding. It shouldn't surprise you. I did not sit alone in a room and rewrite these. Nothing like that happened. This was a very, very, very robust and sort of integrated process. And I did very little of the work. And I will, in just a few slides, give all the credit where credit is due to the folks who did the vast majority of the work. But really, before we got started, we put together quite a few documents that sort of provided our sort of guiding lights for how we wanted to do this. We really wanted more clarity for staff and tribal partners. So we didn't want more policy for the sake of more policy. We wanted clean, crisp, simple policies. And we really especially wanted to highlight the areas where we were hearing from both our tribal partners and from staff in the field that things were uncertain. They didn't know exactly what to do. They didn't get what they were supposed to do. So we really wanted to improve the clarity. Whenever possible, there was an attempt to provide the highest possible standards to best protect Native kids and families, to use the fullest extent of the law to do so. And then obviously, so that caseworkers and others weren't looking at their procedures manual, then looking at the law, then looking at case law. We tried to integrate that all into one place. So the only place someone has to turn is really to the new policies and procedures. As part of the process, DCYF was really committed to honoring tribal voices and partnering with tribes in a respectful, thoughtful manner. And that went well beyond just doing formal consultation. And it went very much in line with sort of your 3 really impressive pieces of guidance, which are the Centennial Accord, the 1003 policy, and obviously the RCW 43376. So you all in Washington have an incredible structure in place that really forces meaningful, thoughtful government-to-government decision-making. And to build on this, in the policies and procedure process for this, I came on board and we ran a big tribal state work group. So before we even got to a lot of the pieces that are required by your amazing framework for government to government interactions, the Office of Tribal Relations, DCYF partners, and then our incredible leaders from the tribes sat down and built a process to do these revisions. So what that looked like was a lot of background information gathering. I had lots of conversations with lots of people, some of them on the record, some of them off the record, some of them very public, some of them sort of like, don't tell anyone, but you need to know, and everything in between. Then we held virtual listening sessions. You've probably seen my face before a time or two where I've popped onto your meeting to say, can you talk to me about what's working? Can you talk about me about what's not working? Then we even went beyond sort of the scope of who DCYF normally meets with. And so we actually did some outreach to out of state tribal partners and hosted a meeting to say, what's working well in Washington for you out of state tribes? We pulled together some legal experts from across the country who spend all of their time working on issues related to ICWA and said, here are the problems we're bumping up against. What are your best solution? We talked to some friends in Alaska because, as you know, the state of Washington and the state of Alaska have a sort of special relationship, and there are a lot of individuals who travel between the two. We met with LICWAC members. We met with individuals who do the shared case management that happens when you have a tribal payment only case, all of those pieces, and didn't do a lot of talking, just did a lot of listening to learn about what could be done better instead of trying to defend what was happening or describe what was happening. We just said, tell us what you need. Then the work group began. It was very cute. We thought it was going to take us 6 months. It took us a lot longer than 6 months, but it was very worth it. And it was an unbelievably iterative process. We would take the old policies, we would revise them, we would meet as a work group, and maybe this sounds fun to you, it was fun to me. We would literally go line by line, sentence by sentence through a policy and discuss what's working, what's not working, what are possible solutions, what are barriers to those solutions, what are compromises to those barriers, what are ways to move forward. After we went back and forth a few times on that, it went to leadership at DCYF. Leadership made decisions. Anything leadership did not agree with that the tribal state work group requested as a best practice went back to the tribal state work group. So DCYF really partnered here and didn't sort of pull any hard lines and say, no, we don't care what you think, we're doing this. There was a constant conversation between leadership and the work group, after which on almost every issue, compromises were reached. Those compromises were then integrated into the policy, and the sort of formal, normal DCYF policy revision process started. So we didn't even start the DCYF process on any of these policies until it had been vetted, re-vetted, and vetted again by the tribal state work group. And of course, after all of that, there were formal 3 roundtables and then also consultation, which is really to honor that key leader to leader, government to government relationship. So all this work was done to get to the new policies and procedures. So I'm sure your burning questions, which would be mine, are who the heck was on the work group, who had to sit through all those Friday morning meetings with Addie for hours and hours and hours. And just, of course, a special thank you to our chairs, Liz Mueller and Bob Smith, who have both been at this for many, many years and whose time was completely invaluable and whose leadership really helped us stick through the hard issues, have the difficult conversations, but more importantly, not give up even after 18 months, 20 months, 24 months of all this work together. You can see our amazing other tribal partners here. To the extent that you are better at Zoom than me, now would be a really awesome time to throw those clappy hands up, put some hearts, any of those great reactions to thank these folks for their work. I think I just figured out how to do it on the fly, which I'm really happy about, because it's really important to remember that all of this work was volunteer work for everyone involved, and it was on top of their already busy schedules, their leadership positions, their day jobs, and everything else they're already doing. And they were tirelessly committed. And not only were they committed to showing up, but everyone on the work group, and I'm going to move to our state partners here and external partners, everyone showed up to all of the meetings with really thoughtful commentary and also a willingness to respectfully disagree when it was necessary and to work through some really difficult conversations about what these policies should or should not look like. And I have to say, I have hosted a lot of work groups like this in my time, and I have never seen a better model for like true partnership without complacency. So I didn't see anyone sort of roll over on anything and say, fine, if it has to be that. I saw a lot of really struggling with complex policy decisions and issues. And I saw a lot more listening than talking. And I know that I learned just a boatload from getting to work with all of the partners, subject matter experts, et cetera, who came to the table on all of these policies. So that sort of leads us to what the current policy development pieces look like. This is how DCYF normally does things. We then reintegrated the tribal state work group back into it so that it could go through sort of the normal process, including, for example, labor negotiations, finalization, et cetera. So we really did not hold back on process, I think is the bottom line. We had a lot of conversations in a lot of different places. And then just by way of our final piece of background, we hosted 3 roundtables and a consultation. This is very customary in Washington, I learned, so that roundtables were an excellent opportunity to troubleshoot any remaining concerns before getting to the formal consultation. And during those roundtables, again, I saw a lot of folks listening, asking thoughtful questions, and when there were concerns, providing constructive feedback on how to improve those concerns, so that by the time we got to consultation, it was really an opportunity to celebrate the important work of the group and make some final tweaks, but mostly feel proud for all of the changes that had occurred. So I'm going to pause just for a second before we get into sort of the substance of things and see if there are any questions or thoughts. If anyone who was on the work group wants to jump in and describe just how much fun it is to talk policy with me at 9 on a Friday, now's your chance.
I'll add in here. It's just, it was a lot of wonderful quality time. And I feel like without that now, I know that we're missing you, Addie. We're missing the group of tribal leaders that you had mentioned, the group of subject matter experts. And now's the time where we're looking at all of the hard work that also goes into the implementation pieces of this. So while it's like a time to celebrate, it's also a time to be able to also be focused on, there's so much work to do here. So just, it's been a pleasure. We're so happy to have worked with you on this. And I think that I just wanted to add in, oh, it's great too to see Ursula's here too. Ursula was a part of that as well. Yeah,
so
come
great.
back. We're always looking for ways that we can bring Addie back and try to hire her on, even offering her some work here.
You guys are so nice. So what I thought I would do is just hit the highlights. So we're really gonna roll here. So if you need me to hit the brakes, or if you have big questions, you jump in there, and I'm gonna ask Kelly, who I feel like I can pick on because we got to work together, to help make sure I don't miss anyone who raises their hand or puts something in the chat for me. These highlights, again, are my personal highlights. That's what we'll call them. So no one has to take any accountability for what they say but me. These are the things that really stood out to me, having spent a lot of time reading the old policies and working on the revisions. These are some of the things in each chapter that I thought were really exciting that changed. There are many more changes than are highlighted here. And I know that part of the implementation process is going to be trainings that really highlight specifically the differences between the old policy and the new policy. And that'll be really important. But since I had the chance to come to this conference and be just a little more academic and a little more esoteric, these are just the things that I think are really interesting and cool. And then because I really believe in transparency on the process, you'll see on the other column some of the issues that we wrestled with as a work group on each of these. So as these were sort of entering into consultation, this is where things stood, and I'm just very excited. So first of all, we made history a formal chapter. Before it was sort of an addendum. This group really recognized that it was really important that all folks who work on ICW issues know that the history is more than just an addendum. It's part of the work that we're doing. We were able to put some new background information in, and we really integrated education on the government to government relationship. I think a lot of us think about government to government on the level of policies, making policies, but we wanted to remind folks that caseworkers from the state working with caseworkers from the tribe are also on an everyday basis engaging in that really important government work. I wanted to provide some context and some understanding around that. I will say this chapter was very fun to write because we had a lot of the primary sources and historians in the work group with us. And so we had a lot of moments where people were like, I was around in 87. This is actually what it said and actually what happened. And I was like, oh my goodness, I was 4 years old in 87. Tell me more all about that. So this was a great new addition, new chapter, bringing it up to the front. Then we have an introduction. The introduction really sets the stage. I think this is a chapter that is often overlooked by caseworkers who are going straight to the answer. But I think for our workers here and for our supervisors being sort of familiar with what this says, because it answers questions you might have throughout the process. Who has to follow this? When do they have to be followed? And sort of what happens when there's disagreement, which becomes really important. In certain areas around LICWAC and impasse procedures. So really sets the stage in a super thoughtful way, and really helps us all understand what these policies are about and what to do about them. So I would say if you have a gray area in a policy that you're wondering about, before you call up to Lena and ask her to explain it to you, I would check the intro and see that it doesn't sort of add that clarifying piece you need and then get you there. After the introduction, we jump right into substance. So I was just on a call with a different state who rhymes with Michigan, talking about how perhaps they should consider also having MOAs with out-of-state tribes. And they said, we don't know any states that do that. And I said, aha, I know a state that does that. One of the really neat pieces to the new tribal state MOA chapter that we revised was it now permits out-of-state tribes to develop agreements with Washington state, which I think will be really important because we know both that there are some tribes that are near the border that cross over the border, and also that there are some tribes and villages up in Alaska that have a lot of families down in Washington. Tribal state agreements are such a helpful way to streamline processes and improve practice and also build relationships. And so now that opportunity has really expanded. This is a place where I feel like I have been bragging about Washington being on the cutting edge of things, and it was a really fun opportunity. The MOA process chapter, I know folks on this call have probably been working on a new MOA or feel like their MOA is stuck or want to revise their MOA, but they're nervous about what that process will look like. This chapter really tries to provide a little bit more of a step-by-step to keep things moving. I know that's been a little bit of a concern in the past. So listening to where we've had problems in the past and then really trying to thoughtfully troubleshoot them was a big priority of the tribal state work group. And the last thing I'll say is I know the MOA template is part of the implementation process and is under work, and it will be posted online as a starting point for things. So pretty exciting stuff. And then one of the sort of secondary things that occurred as part of this process that was really fun is, as you all may or may not know, very soon after ICWA's original passage, because ICWA provides for the creation of these memorandums of agreement, there was a very important document crafted in Washington, which was sort of a master MOA, which many of the tribes in the state then signed on to. And through some sleuthing by a variety of different work group members, we were able to refine the original MOA, which is, I think, a really important piece of ICWA history because that served as the template for states across the country for years and years and years and remains sort of the starting point for a lot of these negotiations. So that was really fun. We found it. We all kind of took some looks at what it was like and really enjoyed that opportunity. Chapter 4 is intake. Again, just providing the highlights. I think we all know what intake is, but what I think are really exciting changes, we talked a lot about making sure that our intake partners are asking that reason to know question and are documenting it, and then also are making that phone call. And I know that's something that's worked really well in the past in Washington, but we had a lot of conversations about when there's the time to make that phone call to ask about the child's tribal heritage or to learn more about the family. we need to remember that tribes often have information that's going to be really valuable to the state's decision making. And so we had some great conversations about collecting what we call collateral information. So not just calling to say to the tribe, hey, this is what's going on, but remembering that belief that and that understanding that tribes are partners in this work and gathering information from them at the same time. The other thing that we really tried to tackle a little bit head on was concerns have been arising about sort of when there's an intake in a licensed home. There have been issues in the past with tribes being able to access, those screened in intakes. And it can be really frustrating if your tribe's child is placed in a foster home, that foster home has had an intake done, and you're not able to get a copy to know what's going on in the foster home where your tribal child has been placed. So we really added that important and exciting piece of information, and talked a lot about making sure that intakes are getting promptly to the tribe so that in-state tribes really know what's going on in real time. And to the extent that they're able to partner in CPS investigations or offer different services to the family, they have a chance to review the same background information their state partners have before going out to do that. All right, CPS and FAR. First and foremost, I think something that was really important about updating this was including the family assessment response stuff. The old policies and procedures came out a little bit before those were embedded in the practice of the agency. And so really important here that it makes clear that at that CPS phase, there is the investigation piece and there's the family assessment response piece. And both of those pieces are areas where the state needs to be meaningfully partnering with tribes. And so really clarifying that. I would say the things that we discussed the most in this chapter are both the need for active efforts to start the moment that there is engagement with the family and that family is going to be screened in and is going to be in the CPS process receiving services. So that's a big change in practice. I was just talking to a different state that rhymes with Oregon about how active efforts really need to start early on, and how there was some great policy language in Washington's new policies and procedures about what that looks like. The other thing that I think we talked about a lot here was, what does partnership look like at the CPS phase of a case? What do document sharing, what do conversations, and then what does it mean to go out together in partnership to do an investigation? It doesn't mean that you call your tribal partners 10 minutes before the investigation that is an hour and a half away from them. It doesn't mean that you let tribal partners tag along, but you don't actually take their thoughts into consideration when making decisions. It really means what it sounds like: partnering, working together to understand the issues that are going on with the family, to think about the services that family needs, to provide those efforts, and then to make sound investigation decisions. Recognizing that more folks who care about that kid and are weighing in on the decision, the better. On voluntary placement agreements, so VPAs. So I would say the highlight about this section, beyond making it its sort of own standalone chapter, is that important reminder that in an ICWA case, a VPA has to happen in a courtroom. So that's not new. That is what the law requires. But I will say, from time to time, there are areas where we could all use to be reminded of the requirements of the law. And one of the things we talked a lot about is misunderstandings around VPAs and what they require. And so by creating its own chapter, we're really highlighting here, you got to go into court. You have to be in front of a judge. You can't sign a VPA if there is any reason to know a child may be an Indian child in your DCYF office, in that parent's home, at the McDonald's over a milkshake. This has to happen in court. And then one of the things that this chapter does is it really helps caseworkers understand how to get that case into court, because it's a little bit tricky, right? It's not what you're used to doing. There's no sort of similar petition to what you're used to doing. So we spent a lot of time figuring out the best way to set caseworkers and others up for success. And also, to the extent that tribes are available and responsive and able to show up and be a part of this decision-making process, which is usually a very fast-paced process, reminding that it is still necessary. It is still important to partner with tribes and to make sure that as parents are making decisions about voluntary placements, they're actually voluntary. And so they've had the chance to talk to everyone who might have insight on this issue. I'm open to questions at any time, just a reminder, but I'm going to pause in a couple more chapters. I know we're really rolling through it. Okay, dependency chapter, big chapter. So what I will say is it used to be one humongous chapter that was everything that happens in court. And there are a lot of things that happen in court, and there's a lot of preparation that needs to happen to get to court. So we broke it down between different parts of a case. So the dependency case really focuses on that dependency piece of the case, starting with when the petition is filed, through the shelter care hearing, on to the adjudication, through to the disposition, and then thinking about what happens in review hearings and otherwise permanency hearings, right? I think that's really important. ICWA doesn't provide a lot of guidance on what happens in review hearings and permanency hearings, but that doesn't mean that DCYF is off the hook and not doing anything. Active efforts still need to be happening. Placement still needs to be searched for. Tribal engagement still needs to be going on. This chapter reminds us of that, even though the law itself implies it, but is silent on it. The other pieces that we were able to really talk about here are what are the standards at each hearing. So this was an area sort of a little bit of confusion. When you go into court at that first shelter care hearing, you can't give notice and have 10 days before the hearing. Your shelter care hearings happen well before 10 days has passed. So that notice can't be required. I know this is going to be controversial because you have judges who are telling you differently. We're hoping to provide guidance. You can't have a QEW at that first shelter care hearing because you can only have a QEW when you've been able to provide that length of notice and you're able to provide all of those other standards, right? So this policy says, listen, at the shelter care hearing, we're really looking at ICWA's 1922 standards. We're really looking at the WICWA emergency removal standard. That's what we need to be prepared to talk about, that and the active efforts to prevent removal. Then it talks about within 30 days, you have to have that hearing after you've given the notice that includes the qualified expert witness, the standard about continued custody causing serious emotional and physical harm, etc., following those timelines. Then after that, you have the dispositional hearing where you make sure you're following the placement preferences. It really creates an important scaffolding in some of the areas that are most confusing. Not because ICWA is confusing, but because ICWA was passed in 1978 and child welfare practice has really changed since the time it was passed, and ICWA has not necessarily changed to keep up. So this chapter really tries to provide clarity about the best way to overlay 1978 with the modern way that child welfare proceedings are happening in Washington so that there are less questions. I thought this chapter was a really fun one to write, but I think that's just because it has a lot of really nerdy legal standards that got to be woven in. But I think it's really important to understand when you're going into court what questions you're going to be asked, what your AAG is trying to prove up, why you're there. And so this should be really a helpful tool for that piece. Okay, guardianships. I am so happy that we were able to create a guardianship chapter. I think it's really important. As you all know, the big conversation we had about this was sort of a reminder that in a lot of ways, guardianships are a better cultural permanency fit. Not in every case, not for every tribe. It's really important to remember that each tribe is unique, each case is unique. But in general, terminating parental rights and adoption often are considered to be less culturally relevant, less culturally competent. And so having a robust guardianship chapter that really sets the stage for how to do these guardianships with tribal families is really important. We also got to do some really, really neat stuff in here where we finally put pen to paper about the cultural plans that we know are happening in pockets of the state already. So in certain areas of the state for a while, tribes have said, sure, we'll agree to this guardianship, but we want in in the guardianship plan how you are going to keep this child connected to our culture, our community, their grandparents, and their family. And so this provides a little bit of a process and a reminder to caseworkers and to tribes to say, okay, sure, we think a guardianship is great, but we don't want to sever ties to culture, community, family just because we're doing a guardianship. What's the plan to really include that in the work that we're doing? We also talked a lot about making sure that at sort of the point where permanency decisions are being made, will this be a guardianship? Will this be an adoption? Will this be a reunification? That tribes are at the table and their voices are heard and they have a chance to weigh in, and that perspective, that opinion, that sort of professional and cultural piece is a part of the conversation and considered right next to and along with all of the other areas of best interest that are discussed when it comes to kids and their permanency plans. Ooh. All right, TPR. We, of course, created very clear guidance around TPRs and what's necessary. I would say the greatest hits list for me, or the thing that I was really excited about Washington, not brand new. This is something you all have been doing that I think is a best practice for a long time, but I love seeing it in writing, is just a reminder that in Washington, there is always the opportunity to transfer a case at any point in a case, and that includes prior to termination. Some of the conversations we had were around how there are quite a few tribes who don't believe in termination. And so to the extent that that becomes the permanency plan, that's the moment when they know transfer is necessary. So we really clarified that. I'm guessing for a lot of you on the call, you're like, well, duh, we've always done that. That just makes sense. That is true. And also I have worked in quite a few other states where they actively oppose that and try and disallow tribes from transfer at that point in the case. So I really think having it in your policies is really helpful to the longevity of that best practice. The other piece was just making sure that when termination is happening, if it is something the tribe does not agree to, that gets kicked up to the next level before a petition is actually filed. So we'll talk a little bit more about impasse in a second. This is even shy of an impasse procedure. This is just to say that to the extent the state thinks that TPR and adoption is the most appropriate plan for the family. If the tribe says we don't agree, we would prefer X, Y, or Z, that caseworker cannot move that forward, cannot file that petition until consulting with their supervisor and the AAG. And it's sort of like a hard stop to require everyone to ensure that at that moment, when that very big decision is being made for a case, that there's a second and a third set of eyes saying, wait a minute, why are we going against the wishes of the tribe here when we know that it's going to have such long-standing effects on this child and this family? Voluntary relinquishment. This is just, of course, the ability of anyone to voluntarily say that they would like to give up their parental rights. Again, here, just two important things. One, you got to go to court. You can't do this anywhere but in court. That's been around a long time. I know that that's been happening, but we wanted to make it crystal clear. The other thing that's really, really key that has been a long time ICWA and Washington practice, but is not common in the rest of the country, is notice to known tribes when this is happening. So that means that even though it's a voluntary relinquishment, tribes know that it's happening and have the ability to participate in the proceeding. So really important, again, to have that in writing. And then there were some conversations about sort of like making sure that the tribe is at the right conversation, knowing that what often happens is an involuntary TPR is filed and somewhere along the way the parent decides to voluntarily relinquish, making sure that the tribe is able to weigh in at both phases in the most appropriate venue. Chapter 11, adoptions. This was sort of a fascinating chapter where I learned a lot, because at this point, DCYF doesn't actually hold a lot of control over the process. It goes out to a private adoption attorney. So a lot of the conversation we had was, how do we set up that private adoption attorney with the information and instructions they need to ensure that that adoption is done pursuant to the requirements of ICWA and WICWA, because it's no longer sort of DCYF's sort of in DCYF's court. It's now in that adoption attorney's court rather. And so we talked a lot about what is given to that attorney, how it is given to that attorney, and what reminders that attorney receives in terms of following the Indian Child Welfare Act. The other thing we talked a lot about here, and this was an ongoing conversation that I know will continue even long after today, was making sure tribes are able to access the home study report. So we created a couple of imperfect workarounds because of the way the law is currently written to allow for tribes to access that report with consent or with redaction. And then we put on our list of things to continue to talk about how to ensure tribes are getting the right documents, including that home study report. So really important stuff here. We also, just like with guardianships, talked about those idea of cultural agreements and making sure that that was a part of the conversation that permanency workers are having with prospective adoptive families, with adoptive parents, particularly non-family, non-native placements. All right, case management for children of non-federally recognized tribes and Canadian First Nations. I would say the highlight for me, or the neatest conversation we had, was really about how individuals who are members of a Canadian First Nation also have dual citizenship with Canada, which meant not only do we need to bring the Canadian First Nation in the loop or into the know about what's going on, but also we needed to remember that the consulate for Canada now needs to be brought in the loop and in the know on what's going on, which has been an oversight in the policies and the procedures historically. And so I think that was really a cool addition to these policies that we made and had a great conversation about. And it was something I didn't know. So I was learning a lot on this chapter. And I think shout out to Talina for her expertise in this area and for being patient enough to educate me on some things that I was embarrassed that I didn't know. The other piece to this that we had a really great conversation about is historically, Washington has done a really wonderful job of recognizing and providing different, not ICWA protections, but additional culturally respectful protections to non-federally recognized tribal member children. And it was really reaffirmed through the tribal state work group that that was a commitment that the state and Washington state federally recognized tribes really wanted to continue to maintain. And so a lot of really wonderful conversations about sort of, we can't provide the same protections as ICWA legally, but what are the protections in terms of continued cultural, continued family, and culturally relevant services that we want to ensure are occurring for those children as well. It was really some beautiful conversations. Sort of, it reminds me of the saying, like, all boats shall rise. Like, no one wanted to cut anyone off or decrease services for anyone. Everyone wanted everyone to be getting the best possible services available to them to the extent of the law. So those were really fun conversations for me. Reason to know. This is the hit list of the hit list of the hit list, meaning this is like the big reason we dove into this. And I think this is really an important chapter, and it's really an exciting chapter. It is the big question that has been out in the field. It is the big question that we've really been tussling with. But what is reason to know? When do we have it? And then what do we do once we have it? And so there was a lot of conversation around what is reason to know. We, of course, looked to the case law. We looked to the federal regs. We hosted a lot of conversations with folks about how much information do we need to know we need to do more work. And the bottom line is, anytime you have any sense that a child might be a Native child, there is more work for caseworkers to be doing to figure out where that child may be affiliated, and then from there to try and work with any of the tribes the child may be affiliated with to verify their membership or eligibility for membership. So really important chapter. Big takeaway is, if you're hearing anything about the child being Native, there's more that you have to do, whether it be questions that lead you to the name of tribes or talking to OTR to figure out if you're asking the right questions, or starting to do that inquiry and notice outreach that we're going to talk about in just a second. All right, inquiry. This was the other big sort of area of clarity, shall we say. But what we really decided and talked a lot about is balancing the experience that tribes were having with the experience families were having. What I mean when I say that is, our tribal partners were like, listen, we are also governments with limited resources. You can't just send us 17 pieces of paper on the same family. It's not helpful. We don't have time for that. And we're also not always sure what we're getting from NAIR versus what we're getting from the AG's office versus what we're getting right before a petition as notice. We don't like how messy it is, how much paperwork we're getting. And also, we don't want you to only send us one thing once, because we want the opportunity to make sure that we're capturing all children who may be members of our tribe and ensuring that Washington State is aware that they may be members so that they are getting the protections of ICWA. And so we've really streamlined the process into a two-step process between inquiry and notice, and we've centralized it at NAIR, but we've also in the policies built a very strong partnership with the AG's office so that legal notice is being sent by the lawyers and inquiry is being sent by the NAIR unit. And we'll talk just a little bit more about that, but really we could do like 4 hours just on this stuff. And so, you know, if you want to talk more, reach out to me, reach out to Heidi, reach out to Talina. I think this is really exciting stuff. I've had quite a few states ask me about this because they're interested in thinking about doing something similar. You guys are certainly on the radar as sort of, again, being really cutting edge. But the bottom line is the NAIR unit is going to continue to do an inquiry at the earliest point in a case where they say to a tribe, we have begun to work with a tribe. And I mean, we've begun to work with this family. We want to know if they are a member of your tribe. How do we find that out? Goes out once from the NAIR with the beautiful genograms. I hear all the time that Washington State does the best genograms. Everybody wants to have the folks that do your genograms doing their genograms. And it comes back or it doesn't come back. After that, one time goes out, it's not until, and I'm going to skip us to the next slide because I know we're at 5 minutes. It's not until the legal notice goes out. That legal notice is sort of this new piece. It's always been happening, but the NAIR unit is now going to prep the legal notice and then hand it off to the AGs who are going to send the legal notice. And then there's going to be follow-up notice and follow-up notice and follow-up notice. But it's going to come once inquiry, 3 times notice. Heidi, I know this is the very big umbrella overview and you know all the details, but I'm just keeping it high level. All of that's going to happen so that there are multiple times where tribes are getting the opportunity, but not so many times that we are wasting lots of trees and wasting lots of people's time who would rather be working directly with families on improving the services that they're receiving. So this is going to be a really important and exciting change. The documents should match and line up so there isn't so much confusion. That's our strong goal. And yes, there will be a streamline answers between NAIR and legal. That is absolutely the goal, is to solve. We're going to magically wave a wand and solve all that right away. I'm just kidding. But we are very actively working on making sure when notices come back, when NAIR responses come back, those are accurately entered in a timely manner and that caseworkers are made aware of that in a timely manner so that things are going just a little bit better. I will say this is going to be a big process change. And I wouldn't say we're moving the Titanic because I think that's not quite that big and I think there's a lot of buy-in, but it is going to take, you know, a time period of change. And so there's going to have to be an opportunity to take feedback, give feedback, and continue to improve this as the kinks are worked out. But I think, and I'm very hopeful that as written, this should really make things more clear and easier. It should help quickly identify more children as Native children without unnecessarily wasting folks' time. I have 3 minutes. So I'm just going to say chapter 16 and chapter 17, all they do is they say, to the extent that we have received responses from the inquiry or notice, DCYF is never making the decision about when to stop treating the case as an ICWA case. Courts are making that decision. And chapters 16 and 17 empower DCYF to go into the court, say, here are all the notices and inquiries we sent, here are all the responses we received or didn't receive. You tell us, courts, what to do at this point. And I think this will be really important because it is the court's authority. It will ensure that when in doubt, children are treated as ICWA kids until a court deems it inappropriate. And that way, no caseworker is feeling the pressure in their office of looking at the responses they've received from the 3 tribes that the child may or may not be eligible for membership in and forced to make that decision on their own. They're partnering with their supervisor, their AG, and then eventually the court. And until the court says this is not an ICWA case, it's treated as an ICWA case. But the goal here is really to also prevent what we know is happening out in the field right now, which is there are cases that have been opened 18, 24 months where there's been no response from the tribe, or there have been 3 tribes that have said no and 1 tribe that hasn't responded, and it's still being treated as an ICWA case. And everyone is kind of like, this doesn't feel like it's right. Something is up here. This should answer that really big question, which is the #1 question we got from the field. Active efforts chapter, it's really fun. I'm very excited. It's a new chapter. It goes into great detail. Huge shout out to our partners at Lummi. They have 196, I want to say, page active efforts guide. This is more like a 6-page active efforts guide. So not quite the same, but it is structured off of the same guide that that Lummi works off of at the request of Lummi and the tribal partners. I think that's really exciting. I mean, active efforts, I think, is the heart of ICWA, really meaningfully engaging and working with families. I think this chapter provides a lot of guidance. More importantly, this chapter has a whole section on partnering with tribes that really provides a solid how-to guide on how to work together as coworkers, as colleagues, thoughtfully and respectfully. All the stuff is really obvious, but the conversations we got to have around what does meaningful partnership at the caseworker to caseworker level look like were so incredible. I know I'm at time. I see it, Kelly. I'm just going to skip to my most favorite chapter, impasse. You guys already know all the stuff on LICWAC and all the others. Don't worry, you didn't miss anything. It's all very important, but you know what? I just want to highlight that the impasse policy is really exciting. This would be the other sort of like, if I could be like, Washington is crushing it. This is one of the chapters I would hold up. It creates an alternative dispute resolution process when there are disagreements on cases. There has been an impasse policy in place due to really good work of tribal leaders decades ago, but we've created a whole new chapter. And this is great because I think what can be really helpful in partnerships and in government to government relationships is when conflicts arise, having a structured, thoughtful way to tackle those conflicts that is that allows for voices to be heard and allows for resolution and compromise to occur before things escalate. And this chapter really provides that awesome opportunity to say, we are partners. We always want to be able to work well together. We're not seeing eye to eye on this issue. So instead of passively aggressively emailing or fighting it out on the phone, we are going to pause and turn to our impasse policy and follow the requirements of this policy so that we can continue to build a relationship within and not in spite of our conflict. So that was a very fast overview of all the cool changes. I'm 2 minutes over. I already know I'm in trouble, so I'm going to pause. But we were able to talk about all of my favorite things, and I will hand it back to Kelly or Anne or anyone else at this point. And thank you guys so much for letting me come talk about this. I'm sure you can tell it gets me really excited. I'm a huge nerd. It's so great to see so many faces of folks that I've had the pleasure to work with over the last couple of years on here. And I'm actually in Washington giving this presentation. I'm up in Bellingham for the day. So it's ever so fitting that I got to jump on and join all of you from your home state. So thank you so much.
Thank you, Addie, for making this complex process so much easier to understand. Great. Any questions? Looks like I don't see any in the chat. I know that next up will be our keynote speaker for closing this afternoon is Kalina Lawrence, and that will be happening at 3 o'clock. And it looks like that is on track 1.